Very good afternoon to everyone, and thank you for joining our session today. We have a power packed panel today with us who will be discussing the implications of the CARO 2020 and what is it the corporates need to look forward in this challenging times. Without wasting any further time, I'm going to directly deep dive into today's topic. What are we going to discuss today? Jump start to whistleblowing in India. Across this quote which said, today's superheroes are like whistleblowers. I think the quote says it all. The relevance and the importance given to whistleblowers and the significance in today's age and time. What is a whistleblower or what is it? Essentially involves a disclosure of certain kind of information in the public or the private realm in relation to any kind of fraud, any kind of corruption, a breach of policy, which has an immediate or potential danger. Now, ensuring that you have a strict, robust legal regime in place becomes extremely critical with the rise of whistleblower complaints in India, and also at the same time, transparency and integrity within the organization itself. It's not just India. Let's look at the SEC itself. Last week, I think the highest amount of an award was granted by the SEC, which was $27 million to a whistleblower, because they not only provided critical links to how to go about the investigation, but also aided in the investigation process. Over the last almost 8 to 10 years, SEC has actually awarded $430 million to whistleblowers. But that's US, which already has a robust regime in place, several laws, regulations in place, and know how to go about it. So let's take a step back and come back to how we deal with it in India. Before even getting into the law, let's understand what are the two basic tenets which are involved over here. Confidentiality of the whistleblower and also ensuring non-disclosure of the identity of the whistleblower. That is the key to achieving an actual proper regime of whistleblowing in India. It's not a new term. It's not just for lawyers. It's not just for auditors. It's not just for accountants or people who are associated with it. I would say every layman and every person working in a corporate is now familiar with the concept of whistleblower, thanks to the latest whistleblowing complaints in India of various multinational companies and banks which have made it to the headlines of every leading newspaper as well as news. What is whistleblowing? We first saw the start or idea of this concept with the new companies law in place which came in 2013. The need for a stricter corporate governance regime in our country. And it ensured that for listed companies, we have mandatorily a whistleblower policy in place, which is provided for in the popularly known as the Clause 49 of the listing agreement, which everybody is familiar with. But the problem with that is it restricted itself to only listed entities and certain categories of companies which are involved in borrowings beyond quantum. So how do you deal with the private corporations? They get away with it. They don't need to have a policy in place. Forget any mechanism. And you can just you don't need to do anything to keep your house in order. The Indian government. Then came the Whistleblower Protection Act in 2014. What did it ensure? It ensured that there is no victimization of the people who are actually coming forward and disclosing information in relation to a fraud, in relation to a willful misuse of their power or any discretion when interacting with a public servant. Again, there is a lacuna over here. We are not bringing the private corporations within its realm. There is no requirement to deal with any kind of private individuals or private corporations. We are looking at the larger picture from a public interest perspective. But with the trend or the increasing amount of whistleblower complaints coming in, most multinational corporations realized that it's better to have a policy in place, which provides along with it a code of conduct, a mechanism how to go about the investigation, and the fact that it's also reported to the auditors as well. This kind of a process is generally done under the aegis of an audit committee. But there is still no law which mandates and says you have to have a policy. Its absence does not bring with it any kind of legal repercussion. We all know the country we are living in. First, we need a law. That also is not good enough. If you're unable to enforce it and implement it, it's as good as not having it in the first place. I think in this background, with the amendments to the CARO 2020 is actually a very interesting step ensuring that let's get up and smell the coffee. We have a stricter regime in place and ensure you have proper compliance. What is the aim of the CARO 2020? The Ministry of Corporate Affairs, right before we went into this lockdown phase, realized you need to have a good corporate governance, enhance due diligence, and enhance duties and responsibilities of the auditors. With the introduction of these CARO 2020, we also saw that now it's important for you to report all whistleblower complaints which are received in a particular year to the auditor, and then it is upon the auditor to consider them, understand the nature of the complaint, the manner in which the complaint has been dealt with, and the quantum involved. So you're not just placing the onus on the auditor, but it's also on the company itself at the first step itself to report about the complaint. Whether it's a fraud by the company, whether it's fraud in the company. These concepts, when I say it first, might sound a little simple for everyone. Okay, there is a complaint, I need to investigate, I need to go and tell my auditor about it. But I think everyone needs to wait till the end of the session and let the experts talk about it so that you understand the complexities and the legal issues which can come up with these kind of disclosures. I'm not going to take up any more time of this panel today. I know everyone has been looking forward to hear to the experts, and considering we have the privilege of having Arpinder and Arun with us today, I'm going to directly put forth a question to them and ask them to share with us their views and thoughts about the CARO 2020 and what they think is going to do to the corporate regime in India. With these reforms in place, how do they actually see it practically being implemented? Over to you, Arpinder and Arun.
Thank you so much, Sahil and Payel, for inviting us for this session. I think the changes in CARO are very, very critical to a company, and they're going to change the way at least the CFO, the finance team, and the auditors interact on a go-forward basis. Just to take 1 minute before I go into the details of CARO 2020, I think the last change in CARO itself was pretty significant. I mean, I've been doing forensic investigation now for many years. I can tell you that the changes the last CARO amendment brought was significant. You know, the definition of fraud, for instance, which was highly debated. Should, for instance, bribery and corruption be included in fraud was a highly debatable topic. There was also a guidance note brought in by the Institute, which if you don't have a copy of, I think you should ask Sahil and Payel for that. I think that's a critical document you must all go through. It talks about what a shadow investigation is for people who don't know what a shadow investigation is. That means when a fraud is found, an auditor actually has to shadow that investigation to make sure they are comfortable with it. And it actually puts down very prescriptive requirements, which a lot of people are not aware of. So I think there were a lot of changes which have happened in the last 3 years. Even though it's 2013, I think I've seen it effectively from 2016 onwards. I would say that's one big change I've seen. Second big change is auditors have started reporting fraud in CARO, which itself has been much more onerous in the last 2-3 years. The last bit is whistleblowers. I mean, on the point which Payel is saying, I can tell you as a forensic investigator, 90% of my investigations start with whistleblowers. That's the unfortunate reality. You have a lot of audits, you have a lot of internal policies. Ideally, a lot of those internal processes should throw up issues But unfortunately, it's still the whistleblower who actually brings forward most of the people. That's a fact. You look at the global large investigations, you look at the Indian issues, it's always the whistleblower who starts it. So I think that is the unfortunate reality. But it's also the good part is then whistleblowing and the whistleblowing process should become a critical part of an internal control process. It shouldn't just be looked at as a legal thing. It should be looked at actually as a procedure which is from an internal control required. I like to put out an ethical dilemma at this point in time. You're a statutory auditor, you go to a company and you ask a company, hey, share all the whistleblower complaints with me. The company will say, hey, I'll give you a management representation. We have no whistleblower complaints in the last one. It's a 20,000 crore fast moving consumer good company. Do you think that's actually possible having thousands of dealers, thousands of vendors, thousands of employees, that not one person is disgruntled or not one person has an issue with the company or the company has actually perfect? It's humanly impossible. Because it's humanly impossible for any company not to have any fraud because it's not easy if you're a large company. You will have some weaknesses. And in fact, it's good to have those weaknesses which come out because otherwise it shows your processes work, which bring out those issues. So anyway, that's a slight background that there was a lot of churn anyway happening in companies between auditors and companies in the last 2-3 years. Second thing which has changed in the last 1 year, is huge onerous examination by regulators on the auditors. I can tell you, even as a forensic investigator, we are questioned by the different regulators when we do an investigation. So if you can imagine the state of an auditor. The auditors have been called, auditors have been examined. The issue, which goes back and forth is to what extent should they go? Are all auditors supposed to become investigators, or do they stay and comment on what the institute has told them to comment on? And how deep do they go? So I think there were so many questions in the media. There was every time a company went bust, every time a company had a fraud in the newspaper, they'll say, what was the auditor doing? The auditor will come out defending himself, saying, I was only commenting on a true and fair opinion. I was only supposed to do this, get a management representation. Then the government came out saying a representation is not adequate. You need to do your own independent procedures. So what that means is now you can't rely on a representation, or to what extent can you rely on a representation? Obviously, the lawyers can go deeper into it, but it brings up a lot of questions. So as Payel said, what do these questions lead to? These questions then lead to changes in the CARO, which is what came out in CARO 2020. So in CARO 2020, obviously, which was supposed to be applicable actually from last year, and auditors were supposed to start commenting as of March 2020 on the changes. Unfortunately, COVID hit us all, and it got deferred, as Payel said, to next year, which is 31st March 2021. But I can tell you a lot of statutory auditors, I can tell you my own firm where I work, we spent a lot of time, examining how we will respond to these changes. And, in some cases, the government has said, you have to give a representation and you have to comment if there are any legal cases, for instance, around Benami transactions. Well, in other cases like whistleblowing, we have to do a lot more. So it gets into a gray area now on what extent do we have to comment on. So I would say there was a lot of work happening by all auditors across India. There was an exposure draft which was issued by the institute even before COVID-19. Every auditor was examining it. But I think it has brought a lot more onerous responsibility on the auditor. That's the bottom line. I think the auditors are now supposed to comment on a lot more areas like Benami transactions, loan to banks, and there are a huge plethora of regulations which they now have to comment on. And they've been very specific that this is the duty of the auditor to do. As a result, I think the auditor is going to become a lot more skeptical. He will have to ask 100 or more questions from the CFO. I think the information will have to go much more detailed. I think so the audit, you can be rest assured, will become a lot more onerous on a company, and it will also become a lot more onerous on the auditor. It also exposes everybody to a lot more risk. And at this point in time, I would say the scale of audits will definitely change than what you have done in the past. Every aspect will require obviously legal inputs because each one of these is very technical. Is a particular case a fraud or not, which is the biggest thing, is always debatable, even though the definition has been clarified. To what extent is the fraud done by the company, on the company, again, is a very legal interpretation, in my view. Obviously, forensic investigators and companies can come up with the facts, but you need legal advice on that. And also the duties and responsibilities on the auditor and when they can be held responsible also becomes a lot more onerous and legal. So I think considering this, there's a lot of changes, and I'd like to hand over to Arun, and then I'll jump back in as he's talking on the specific sections which have changed. Arun, over to you.
Thanks, Arpinder. Arpinder has set the context of the examples which I'm going to speak through. So we will talk some examples and intricacies of loans, Benami transactions, actual definition, how it has changed in the whistleblower part of Caro. So we will take a little bit of deep dive in each of these areas and discuss. The most trickiest area are loans and the whistleblower complaints itself. So first we will deep dive on the loans. First time the change has been brought in to say that the auditor will have to review and comment upon the end use of the funds borrowed, which is a very, very wide expectation because there are companies which will borrow 100 crores, there are companies which will borrow 10,000 crores. So how is the auditor really going to review the end use and satisfy himself that the funds which was borrowed has been actually as per the terms of borrowing? It is going to be a real tough situation for the auditor and for the companies also to prove, because companies have a network of entities. So they don't really look the color of money. They will transfer the subsidies. It will come back from subsidies. So really a track of all of this and still provide a comfort to the auditor that all the borrowed money was only spent on the company's main purpose is going to be really difficult. A related change around this is also that sometimes the company will not pay the bank, and towards the end of the year, they will regularize. Now, the change has been brought in to say that if even one quarter, if the company did not pay the loans and was not regular, the auditor has to comment on that, even though by end of the year, the loans have been regularized, so that the health of the organization can be put at public, so that the investors can really assess whether the company is really healthy or not. It's a related change they made to keep in line with IBC. The other change is in end use between long term and short term. So it was there earlier also, but now they are specifically telling to call out, saying that what was the amount which was supposed to be used for short term, which has got used for long term, or vice versa. So these are some of the changes in the loan section, which are going to be really difficult for the companies to provide evidence and also for the auditors to assess. Now, the related point on loans is the renewal of loans, where companies borrow and repay an existing loan. Earlier, it would be a subtle comment or a subtle notification in the balance sheet where the loan will move from bank A to bank B. But now, if a overdue loan was repaid by borrowing from another bank, then that has to be specifically commented upon and notified in the books, saying that it was a overdue loan and the company borrowed to repay. So in technical terms, evergreening of loans will have to be called out specifically by the auditor. That's a big ask on the auditor's side, because he will have to assess whether the repayment of loan was for the purposes of interest, was it purposes of payment terms, or was it actually evergreening. So they have to really assess the underlying purpose for which the loan was repaid, the loan was renewed, the loan was extended. It's going to be a real difficult situation in some industries like EPC, contract driven, real estate driven, where the loans are refurbished. So it have to be very a fine line for the auditor to look in and comment upon that. And the last piece on the loans is on the borrowing by the parent company using subsidiaries' assets. So there has to be a specific call out saying that why is that the parent company is not able to borrow using its own assets and they have to rely on the underlying asset of the subsidiary company, or otherwise the pledging of the subsidiary shares. So both are also being really brought out based on the recent cases and the findings by the MCA and the SEBI. And they have called out saying that the auditor will have to comment upon any pledging of subsidiary shares or using the underlying assets of the subsidiary by the parent company for borrowing when they are not able to borrow using their assets. These are all broad changes which has been brought in the loan section, where the auditor will have to specifically call out, comment, review when he has to perform his work procedures. Now, the tricky part is it is applicable from 1/4/2020. The ICA is yet to come out with guidance notes. So all the limited companies will have to do their limited review in July. So how are they going to really handle the first quarter? The jury is yet to out, but there will be a lot of questions. There will be some precedents to be set, but we need to be really watching out on how June and July goes across, because all the listed companies will have to do a limited review. Some of these will have implications in the reporting for the auditor. Moving on from loans to Benami transactions. Earlier, if the transactions were outside the books, by indirectly related, the auditor need not have bothered. But now they are telling to review every contract of the promoter, directly or indirectly, cash or non-cash, specifically non-cash transactions, which have future impact, may not be having impact this year, to be reviewed and commented upon in the current year itself, though there is no cash transaction right now. That's a big leap of review the auditor has to do, because when there is no direct financial impact this year, normally they may not focus because they have to focus on the current year. But now the changes have been brought in to say that, okay, if there's even a future impact because of the non-cash transactions, the auditor will have to comment upon. Now let's move to the subject of fraud and whistleblower and its reporting, which is the most trickiest. By deleting two words in the CARO from 2016 to 2020, they have widened the net like the universe. Really, that's how I see it. Because earlier, fraud on the company was always simple. It's fraud by the vendor. It's fraud by a third party. Fraud by people who are not related to the company. By deleting two words, employees and officers, along with the fraud by the company, actually the net has been opened up, including indirectly the promoter, management, stakeholder, where all of them are looking forward to the guidance note, what the ICA is going to say. But by definition, the net has been so much widened that the auditor will have to look by the company means by anyone in the company. So that means if the board has appointed the auditor, and if the auditor looks or has something doubtful, anybody, including the board member, founder, promoter, employee, officer, he has to look into it and comment on that. Now, that's going to be a lot of questions by the auditor to the company. How are they going to really assess that? Because the company also has to have a framework. It's not also that auditor is going to do all of this. He also has to push the company to create a framework which is going to really give him a comfort that fraud by the company on the company, there is a way to detect. And the auditor is going to really test that and also do some bit of testing himself so that he's comfortable that the process is really working. So that's a real piece of work which the compliance, legal, the auditor, the forensic auditor will have a work, because there is, all of them have different stages of framework, but a comprehensive framework to give comfort, I don't think many companies really have, to give that kind of comfort to the auditor, saying that they have swept and put a framework which will give that by the company, non the company has been adequately covered, and the stakeholders can be assured of that. Moving on from there, whistleblower complaints. Until little while ago, auditor will have to look through the whistleblower complaints, ensure that it has been adequately taken care, and if there is a financial impact, you may have to just look into it and see whether it is pervasive or not. But now the change is whether whistleblower complaints are considered. That means the auditor will have to not only evaluate whether the complaints have been adequately addressed, but also have to assess whether it is pervasive from the person who has committed and also the function and the process the person has been working on. That means he has to assess the pervasiveness irrespective of whether the company has completed the investigation or not. Yes, he can give a leeway and wait for some time for them to give their proceedings, but he also has to consider in his audit procedures whether it has a pervasive impact or not. So that opens up the question in terms of whether he has to look into all the whistleblower complaints. Answer is yes, because he has to assess whether the whistleblower complaints have financial impact or not. It cannot be the choice of the company or the audit committee or the compliance head. So he has to go through all the complaints to see which one will have a financial impact and then discuss with the company what they have done about it. And if he is satisfied, then he can only extend a little bit of procedure. If he is not satisfied, he can push for more work by the company, or he can also extend himself by doing further work to satisfy himself. Then comes the second question. If the whistleblower complaint is to the media, not to the company, to the auditor, not to the company, what are we supposed to do? It's really a legal situation. I don't have the right answer, but there are more instances where people are blowing the whistle to the auditor and not to the company. So in this situation, what does the auditor do? So jury is yet to be out. Each one is evaluating legally how to address that. But these kind of situations will increase because once the company is not going to respond or react to the whistleblower complaint, now there are more avenues for the whistleblower to reach out. First of all, the media is wide open. And now that learned people will understand that auditor has a responsibility, they'll very well also blow the whistle to the auditor. It's going to be a tricky situation when an auditor receives a investigation, what he does, but we need to really evaluate when it comes legally and practically by procedure, how do we deal with this?
Arun, if I can come in at this point for a minute. So I think one thing I'd like to just add, just practically on this, because this actually has led to a lot of pain in the past, and I think will lead to more pain. 2-3 things everyone has to come across, which I've seen companies do it incorrectly. One is you get a number of complaints. Let's say you get 10 complaints in a year. 6 out of those 10 complaints people think are frivolous or not relevant. But it's very important that the company has a process to document why they think it's frivolous. It's not good enough to just say, I woke up in the morning, I looked at the complaint, my gut feeling tells me it's not an issue. You can't treat with whistleblowing assuming a gut feeling. You could be, and most companies have these investigators who work with the police or ex-army or and they generally say, my gut tells me this is not an issue. I used to hear a lot of that in the past. I think that is not going to work going forward because I can tell you that statutory auditors will not accept it. If you don't have a memo, if you don't have a preliminary assessment, it's not going to work. That's one issue I've seen in the past. Second, the way you collect evidence. A lot of time companies start investigations which are very big investigations and they don't start collecting evidence in the right manner. Please, that's another mistake I've seen companies do. Don't fall into that trap, because when you get a report and you share it with somebody and they say, how did you get the evidence? And you say, oh, this is how I got it. The company managed to get into something. You start, giving vague answers. It doesn't work. So I think you have to plan properly and do it correctly from day one. Third, if you have an investigation which is regulatory, when I say regulatory, that means it could be a bribery and corruption issue, or it could be an antitrust issue. Please involve lawyers, because if you tomorrow do an investigation and say it's privileged or it's confidential, it won't work. Because just because some accounting firm has done an investigation, it doesn't give you any confidentiality or privilege over your delivery. So those are some important issues I've seen in companies. So I would just say, just don't fall into that trap, because you have to do it properly going forward, because auditors are going to go into detail. Sorry, Arun, back to you.
Thanks, Arpinder. Very valid points. I have one last point and then I'll hand it over back to Payel. it's time to really relook at our whistleblower policy, how good it is, how effective it is, and most importantly, vet it legally, whether it is in line with the current changes in the Companies Act and CARO, so that we are first of all in line with the law. And second is, we are doing the right thing by administering that and making it work, because that's an important pillar of governance for all companies. Thank you for this opportunity. Back to you, Payel.
Thank you so much, Arun. If I could take 30 seconds and briefly summarize what I understood from this insightful and really helpful discussion is there's a lot more for the auditors to look into. The scale of audit is going to change dramatically. And separately, there is going to be the fact that there's a significance of documentation which is in place, and there is a need to assess all complaints going forward. Having said this, I'm going to now move a little forward and request Sahil to tell us, considering we have this now new regulations in place, a regime being established, and reforms introduced, how do you go about this? How are you going to look forward in this particular direction? What are you going to do different?
So, till now, what you've seen is that some companies have had whistleblower policies. Some companies are required under law to have a whistleblower policies. For example, listed companies. Some other companies are expected to have a vigil mechanism. Some other companies, international companies having a presence in India would have proactive policies for whistleblower complaints. Now, practically speaking, it will become hard for a company to ignore a whistleblower. It's going to be difficult for any company to argue that it wasn't received in the correct manner. Till now, you've actually had situations where the typical company would set out a window where they would expect to receive a whistleblower complaint. And if a complaint wasn't received in that exact manner, they would not hesitate and argue that they've not received it in the correct window, and they'll try and sweep it under the carpet. This concept is going to undergo some sort of a sea change. The general approach now will evolve, and it will move towards what is a triggering event. The concept of a triggering event should be a wide one, which will funnel all such triggering events to one responsible group for actually taking this matter forward. Step two that you come to now is when a complaint is received, how do you handle it? There's no one size fits all over here. So the question that naturally arises is, what do you do with all the noise that will inevitably come into this funnel? For example, in any organization, you have aggrieved individuals. You have somebody out there with personal issues against somebody else who will misuse such a window. How do you ensure that in this entire cacophony of complaints that will flow in, you give each their appropriate due, and the correct whistleblower, the true whistleblower complaint, is not actually missed out? The starting point of this is some ordinary inquiry in response to any allegation. This will ensure that there is an informed decision taken on the way forward. There are some situations where an informal inquiry may very well suffice. But whenever you do or whatever you do, keep in mind that the reason for that should be considered and appropriately documented, preferably in a document that is covered under attorney-client privilege. Keep in mind, this is a document that will need to be disclosed to and should satisfy your statutory auditor. We've just heard about from EY's experts on what the statutory auditor will look at. So when you move forward practically, make sure your house is in order and it satisfies the auditor. Some factors that you need to keep in mind when you are considering the way forward. Number one, the source and the credibility of the information against regarding the alleged misconduct. Number two, the nature of the misconduct itself. Is it a severe one? Is it not so severe? Is it one time or is it recurring? Is there any angle of criminality? Is there something that touches on internal financial controls? Is there something that touches on the integrity of management? The seriousness of the situation does tend to come out when you consider this. The other thing you need to consider, and which will decide on your route forward, is What kind of a company is it? Is it a public company? Is it a highly regulated sector? Have you seen prior issues? I mean, any prior investigation in that company? Has the company faced any prosecuting? Or is it something as simple as requiring disclosures under law? All these things will decide on the route you take when you receive a complaint. As far as the advantages of doing things in the correct way, well, it allows management and the board to take informed decisions. That's a given. You identify the people responsible for the misconduct, and you're able to ring fence the issues when you identify it. You are able to provide a mechanism to halt problematic conduct and future violations. You're essentially cleaning up your house. That's a good thing. You're moving towards a culture of compliance. You're seeing a sea change in India. You're seeing people move and do things in the correct way. This is one such thing. It will, or it should help the company before a regulatory authority, because tomorrow, if the matter goes before a regulatory authority, the whistleblower is not satisfied with the investigation and goes to a regulatory authority, the authority will come calling to your doorstep, at which point it becomes obligatory upon you to show that when you received the complaint, what steps you undertook. Did you clean up your house? What was the length and breadth of the investigation you undertook? And if you have done a satisfactory job, any regulatory authority should be satisfied with that. So it will help you before a regulatory authority. It also insulates the company with regard to the level of compliance that is required. Those are the advantages of doing an investigation correctly. Consequence of not investigating could be rather severe. At the outset, it's going to invite criminal prosecution or regulatory action against the company. And number two, and this is something we're seeing a lot of in India of late, the reputational issues or criticism that a company faces when they have not taken proper steps can be massive. Companies can be made or break with this kind of a situation. The issue becomes, how does CARO 2020 affect the company of today? This is a slightly sensitive issue that we're coming to. What CARO 2020 does is that it requires a statutory auditor to check on each whistleblowing complaint received. Now, it's expected that the auditor will step in and conduct their own shadow investigation to ensure that the approach taken by the company is satisfactory. You can't be satisfied with the word of the company anymore. The statutory auditor will do a deep dive. What does this mean for the company? It means that your investigation is open to some sort of supervision, the statutory auditor. The sequitur will be that if you haven't taken a particular step, the auditor will probably ask you to do it. Otherwise, he will say, I will only issue a qualified opinion. No company wants to take that risk. The next issue that you're going to deal with, how do you share information with a statutory auditor? The team shares anything in writing, including the report itself. You can be sure that the auditor will ask you to waive legal privilege for his own requirements, because he'll need to work on it and he'll need to put it in the accounts of the company. In one shot, you've essentially waived privilege on the report, and that's not something that the law contemplated. Essentially, you need to find some balance that needs to be achieved between attorney-client privilege and the compliance of a company and its statutory auditor under CARO. This balance is not here yet. I think with time, we are going to achieve it. So that's my thought on the way forward.
Thank you, Sahil. I think it has given us a holistic approach or an overview as to how to, approach this entire issue from a legal perspective. And considering I can see a few questions lined up from the legal angle as well, I'll come back to you, Sahil. But before that, going back to Arpinder, considering the implementation has now been delayed due to the COVID situation, how do you think this entire introduction of CARO 2020 is going to impact when it comes to implementing this new regime? Arpinder, I think you're on mute. You need to unmute yourself.
Oh, sorry about that. That's the problem with COVID. You keep talking and no one listens. So as Arun had mentioned, we're already into it because it's applicable from 1st April 2020 till 31st March 2021. As a result, I think most companies, they should be getting whistleblowing complaints as we talk, because whether we like it or not, companies still have operations. People will still have issues. As Sahil correctly mentioned, people try to game the timing issue. I got the letter, it was dated on 2nd April 2020. Or was it dated? I think those are all very, questions which are not relevant anymore, because it doesn't matter whether you got it 2 days after the year end or 2 days before. The reality is you have a complaint, you have an issue. So I think whistleblower complaints are not stopping. They will continue, and I think companies, at least on the whistleblowing side, will have to deal with it. I think the advice which Sahil also gave and I'm also giving is, please take every complaint seriously. Have a documented process. Have a fraud response plan so that you can at least start documenting everything. Because the worst thing you can do is get to March 2021. Have the auditor sitting on your head asking you for all complaints and investigation reports, and you have nothing ready. So my request to everybody is, use the time in COVID to start preparing your fraud response plan, start working with law firms like NDA to start documenting everything. Get your past also cleaned up, because there's some complaints which come back to you every year because you don't deal with it properly. As Sahil says, the whistleblower never goes. Trust me, I've had whistleblowers who send me reminders. Reminder 1, reminder 2, reminder 3. So trust me, those days are over. They don't go. So reality is, you have to face it, you have to investigate properly, and you have to respond properly as per a process. So I would say a lot on that. Second is on the banking side also. As Arun said, correctly, I find the second biggest issue will be responding to compliance on the banking terms and banking loan terms. Companies don't do a good job of tracking their loans. You take a long-term loan, use it for short-term purposes. You mix it up, pledges from subsidiaries, moving money between a parent and subsidiaries. Companies just have to become more disciplined from day one in April in the way they account for loans, the usage against loan, and the movement of loans. So I would say all of this is now going to be open to the auditor. You have time in the next 1 month till the lockdown opens. Please use it wisely to get your systems in place. There are a lot of lawyers, there are a lot of accountants, everybody can help you, but please consult and put it in place.
Thank you, Arpinder. I think the takeaway from here is adapt to the new normal, because it's not going to stop over here. It's not a standstill. It's not a downtime. But actually, you might see a way more whistleblower complaints coming in. So lawyers, accountants, corporations, everybody is going to be busy. Since we have moved to the last 15 minutes of our session, I'm going to quickly start with the questions which have come in. Sahil, I'll first move to you and check with you from a legal perspective, actually, the questions in relation to whether we even have an adequate regime or a mechanism in place which protects whistleblowers.
So, short answer to this is, we can do better. As of now, any sort of whistleblower protection regime in corporate India is policy driven. It is not under law. Having said that, for listed companies, you are expected to have non-victimization policies and all that in place. And you're supposed to document it appropriately. Non-victimization, non-retaliation, non-discrimination, all this is required, but it's policy driven. We need a stronger law in something like this. And it needs to be a law that takes the length and breadth of corporate India, including the various kinds of entities that we have in India, into play. Victimization of a whistleblower, unfortunately, is something we have seen a lot of, especially in PSUs. We've seen front page news where whistleblowers who've actually come out and have tried to do the right thing have unfortunately had bad things happen to them. This cannot be permitted to happen, because the whistleblower can be a very, very important source of information, any potential wrongdoing, and he must be protected. So yes, we need to do better on that front.
Thanks, Sahil. We have a very interesting question right at the outset when we started off this session itself. And it said, a whistleblower is basically leaking an information which has been recorded by a person, that person from whom the information is coming is not aware that it's being recorded, has not consented to such a situation. So in this light, how do you deal with such a scenario, and what happens to the basic right to privacy, considering we have new Supreme Court rulings and privacy law in our country? How do you think we are going to tackle with a scenario like this? Sahil, Arpinder, your thoughts on this?
Arpinder, you want to go first?
So I'll go first and then I'll leave the legal aspect to Sahil, because on whether it's, I remember Sahil and I did a case together and he kept arguing about this poison fruit, right? The poison fruit from the whatever poison tree, as lawyers put it. But he can go into details on that. But to answer your question, I think if a person is doing a wrongdoing, let's say if a person is saying that go pay a bribe, and an employee goes and records it. I mean, practically, I think as from a compliance and forensic perspective, if the person blows the whistle and shares a audio or a videotape of that particular person saying, "Hey, I want you to pay a bribe," and he turns out to be the general manager or the CEO of the company, I think the company has to investigate, irrespective how the person sourced the information. I'm talking not legally, I'm talking only from a compliance perspective. We have to take into account all information which comes to the privy of the whistleblowing and hotline, irrespective of how it's been produced. Now, obviously, I think it goes into whether that can be used as evidence at a later date. Obviously, when we do investigations, we do ask a custodian, as I put it, or a person we're interviewing, that do you give us permission to record your conversation? And once he only gives us permission, do we actually record it? So everybody follows the right processes considering privacy. But I would love to hear from Sahil on the poison fruit.
So there's no great answer to something like this. First things first, let's understand the hat we are wearing over here. You're wearing the hat of advising a company with regard to an internal investigation. In that mode, the role of a company is to widen the funnel as much as possible and obtain as much information as possible to run a proper investigation. If there is any wrongdoing that is happening in the company wants to know about it and wants to run a proper investigation. Now, the source of that information, the starting point of that, may be on a tape which may not have been obtained legally. You can certainly start an investigation and start getting to the bottom of facts. When you come to the end of the investigation and you have some evidence and you want to file a complaint against somebody, you will file it before the criminal justice system or anything that you want to do in life. And the justice system will figure out what is admissible and what is not admissible. Now, wearing the hat of a lawyer who argues in court, what I have seen is that more often than not, evidence tends to find its way before the court and gets considered by the court. There's no straitjacket formula to say that if the person didn't give a consent, you can't use it in a court. It doesn't work like that. You can argue it in court, somebody will argue against it, you figure out what the judge wants to do. So wearing the hat of running a proper investigation, I'll say use that piece of information, start your inquiry. If you find that there is some sort of meat to the complaint, make sure you run a proper investigation, and that's the correct corporate compliance to be done.
Thanks, Sahil. I think we'll take a little diversion from whistleblowing and everything, and I'll go back to Arun actually. He dealt with the aspect of evergreening of loans and more liability being placed on the auditors. We have a very interesting question, which I would want your Sahil's perspective from legal angle as well. What happens to the liability of the independent directors in case of such camouflage transactions? Borrowings from banks with different heads or loans from between parent and subsidiary entities, or huge transfer of amounts. How would an auditor look at it? And followed by Sahil giving his view from a legal perspective on the director's liability on this issue.
What the auditors will look for is what has been disclosed to the board at various point of time, because the board of directors and the independent directors are not in the regular business. So what will the auditors look for is what has been disclosed about the borrowing, then update about the borrowings, and what is the frequency and what has been disclosed. If some of these disclosures have not been made to the independent director, then the auditor will take a different approach of practically approaching independent of the company, talking to the director and saying this is what we have seen. But if he sees that this information has been shared with the independent director, then he will have to decide how to deal with it. Then that will have to be legally dealt with. Okay, there is nobody independent in the organization to speak with. Then he has to approach legally. That's how I see it practically, how an auditor will approach. Over to you, Sahil, from a legal perspective.
If an independent director is truly being independent, he is never going to sign off on any camouflage transaction or any transaction that isn't kosher for that matter. What he needs to ensure that his objections, what he has to say, are adequately documented in a certain place, whether it's in board minutes or whether he's written to the board and warned against that particular transaction. However it be documented, it needs to be appropriately documented. So to the extent he is not consented to and not part of the decision to do that, he may have to face the pain of going through some sort of proceedings, but at the end of the day, he should walk out of it. If he has consented to it, he needs to face the consequences with the rest of them. You're on mute.
Sorry, my apologies. I think we're going to go back to the whistleblowing regime itself, which has been our main topic of discussion. We have often seen it's situations where I think which Arpinder had briefly touched upon the fact that frivolous complaints itself are in place. So how do you deal with a situation when there is a false or a framed complaint? And during the course of the investigation, if you find that a whistleblower has a vested interest, how would you go about dealing with such situation? I understand as a part of the investigation team, how we are going to look at it or how we are going to go back to the policy as to how the policy deals with the situation. Suppose the investigation is done, concluded. Sahil has given his report and submitted, okay, it's a false complaint. There is no evidence to substantiate on this. Arpinder, how you as an auditor, are you going to look at such a situation and what would be your approach towards it?
As an auditor, if there are many frivolous complaints, if a person has made a frivolous complaint and after the investigation, Sahil says there is no evidence to prove that there was actually any wrongdoing, and actually the complaint was frivolous and here is the way the investigation was done. I, as an auditor, would follow my guidance note, which would say, make sure the investigation was done with proper people, it was done with a proper plan, all evidence was looked at, all procedures were done, all people required were interviewed, everything was done. There was nothing I felt was fishy, where Sahil was in cahoot with the CEO trying to put it under the carpet. In that situation, I think the auditor will have to say it's fine. Let's move on. There's no fraud. And it is a frivolous complaint. And then we leave it to the legal team to figure out, as per the policy and the law of the land, what to do on frivolous complaints. Because a frivolous complaint could even come from a third party or even sometimes a competitor, which is causing disruption in your organization. But that's a different aspect. But I, as an auditor, would have to take that on record if everything mentioned in my guidance note has been ticked off.
Sahil, any other thoughts on this? Or before we move to the next question, otherwise?
We can move to the next question. I think the minute the investigation is over, from the team's point of view, you're done about it.
So I think we talked about the fact about what evidence is brought on record, how we deal with that evidence from an investigation team perspective. I think one of the questions is there's no concept of a tainted evidence. So evidence which is being brought forth, there could be a separate case, the fact that, evidence is illegal, which is being dealt with. So, I mean, I think when we are, as lawyers, we are dealing with investigations. I think there's a different way of functioning, you as a criminal lawyer or a commercial lawyer looking at a particular evidence and an investigative lawyer looking at it. How would you deal with a scenario like that and with respect to the evidence which is placed before you to decide on its legality itself?
Question. So when you're running an investigation, you rely on all sources of evidence as you are able to obtain, all points of data that you're able to obtain. And I'll give you an example. I mean, if you're taking a person's laptop, chances are it's a company given laptop and the company has adequate policies and it belongs to the company. So you can just take it over. And the contents of the laptop are fair game. To the extent there is anything private on it, chances are you are not going to look at it because Arpinder will guide you that any forensic service provider tends to keep the private stuff out. They don't look at the private as part of their forensic advisory. So none of the data that actually comes in is something what I would call as tainted evidence or illegal evidence. It's usually evidence obtained as part of the investigation. And then you put it before a court of law. And if the court of law decides that it's something it wants to rely upon, so be it. I think that's the short point.
We just have 2 minutes left with us, so I'm going to go back to Arpinder and Arun actually on one of the questions which were dealt, issues which were dealt by them in relation to evergreening of loans. So, other than Caro, which has actually enhanced your duties and responsibilities as an auditor to look at on the financial borrowing, are there any other aspects which you will look into under any other law or regulation with respect to short-term loans which are being used for a long-term purpose? So, as an auditor, what are the other aspects or regulations you would look into other than your duties under Caro?
I can answer that, Arpinder. So the primary reporting on the loans repayments is driven by the Companies Act and the Caro. And your term sheet with the bank, which are governed by RBI. Beyond that, there is no other law really looks into it. There may be touch points in IBC and touch points in other laws here and there, connecting points, but primary reporting is driven by the Companies Act and Caro, and to some extent RBI bases the term sheet which has been signed between the bank and the borrowee, so that he has to comply with certain things. Beyond that, there is no direct law which talks about the disclosure and things about loan. Others are all peripheral things which will connect a dot, but not direct.
Thank you, Arun. I think I will have to bring an end to this session today because we are just way past. I think it's almost 4 already. So I'm going to thank Arpinder and Arun immensely for joining our session today. And I think the audience would have gained a lot, understood the nuances of the Caro 2020, because today all lawyers, auditors, I'm sure, are making the most of this downtime, supposed downtime, to understand what this law is all about, how it's going to actually function, so that we are all geared up and we know how to deal with it once we are back to our regular routine.